I'm Patty Limerick from the Center of the American West. I'd like to welcome you tonight. I would like to point out that it is not snowy and it is not bitterly cold, which makes you wonder if this is actually a FrackingSENSE talk, because we tend to go for daunting weather, which has tested your character before, and you've come through beautifully, and now you get a little bit night off of testing your character against the elements. So this is the return of FrackingSENSE, and tonight launches an exciting lineup of speakers. The next talk, 2 weeks from tonight, is Roger Frawa from Jemez Pueblo, who is leading an enterprise and organizing a follow-up to the Council of Energy Resource Tribes, succeeding the Council of Energy Resource Tribes, a consortium of tribes working in energy development. And then we have Pete Morton, formerly from the Wilderness Society, who will be speaking on natural gas impacts on wildlife. And then we have Norman Warpinski, who knows more about the actual workings of hydraulic fracturing in shale, what actually happens when the frac fluid hits the shale. And then we have Josh Joswick, who is a former La Plata County Commissioner and is now with the Oil and Gas Accountability Project. Plus, we have a special FrackingSENSE event on Monday, March 10th. Former Senator Timothy Worth and former Environmental Protection Agency Region 8 Administrator, who is also former Chief of Staff for former Senator Worth. They're very present. I'm sorry I keep putting them in the past tense there. All this formerness is suggests that they're pickled or something, but they're not. They're very much alive and very engaged, and they will be here in a kind of back and forth joint talk on our topic of fracking and natural gas development. I should note that this event is made possible by a grant from the National Science Foundation Sustainability Research Network for a major project on hydraulic fracturing and natural gas development. And I also want to note that the National Science Foundation does not endorse and is not burdened with responsibility for anything I say or anything said in the series. They don't really spell out that it's about me. They don't really say that I am particularly limited, but we are all just here with their kind sponsorship, but not with their responsibility. As usual, it is our priority to make sure that everyone who came to hear the speaker gets to hear the speaker. I'm hoping to come up with a better idea this semester, but for now we are sticking with our usual FrackingSENSE Center of the American West request. If you disagree with the speaker, and this is a contentious topic and we know that, so if you disagree with the speaker, you may note your difference of opinion by sighing with exasperation, or snorting with skepticism, or even hissing with bitter disapproval. But you must stay within the boundaries of respiratory protest so that you do not disrupt your neighbor's ability to hear the speaker. I'll come up with something better, I swear I will, but I'm going with that for now. I forgot to tell you that.
No, that's good.
Is that okay?
Oh, yeah, that's good. Just no,
they're hissing at my prohibition, or not, it's not prohibition.
Just no tomatoes.
No tomatoes, that's fair. No vegetables.
No vegetables.
No vegetables in our protests, no. And now we'll be sticking with the drill of having you write your questions on the little sheets in the program. Folks from the center will be walking around collecting your questions within 10 minutes or so of our starting. They'll bring them up to me, I'll sort them into categories, and they'll be distributing more little sheets of paper if you need them. Not everyone is enthusiastic about the plan of writing questions, but I'm still intoxicated with the fact that I'm able to make sure that every single question gets asked, in contrast to the limited number of questions we can cover if we go for spoken questions. Now, I'm always a happy person when I am introducing FrackingSENSE speakers, but I may be particularly happy tonight. Our speaker is Barbara Green of the law firm Sullivan, Green & Seavey. Barbara Green has represented local governments in cases involving land use, oil and gas development, mining, water development, water quality, and low-level radioactive waste. She has been involved in a number of significant cases involving local authority over oil and gas development, and she has worked on oil and gas regulations adopted by counties and municipalities. When I first heard her speak at a water conference, I was instantly rescued from conference-induced drowsiness, and I came suddenly to attention, recognizing that I was hearing a person who has had extraordinary experience in the issues of local resource use and governance, and also a person who reflects on that experience with real intensity and energy. It was on a panel about the negotiations between the Denver Water Department and Western counties, so it was a heated and intense issue, and the equanimity and depth of thought that she brought to it was extremely refreshing, as refreshing really as a cold glass of diverted water. So, And then, when I ran into Barbara Green at a restaurant in Gunnison, and when a brief conversation yielded several quotable remarks that I thought about for months, the resolution to have her give a presentation for the Senate of the American West was instantly called into being. So, join me in welcoming Barbara Green, speaking on oil and gas permitting. Who's in charge? Doesn't matter. Barbara Green.
Thank you.
If you want to stand, if you want to sit.
Is it okay if I sit? Because when I stand, there's no difference, actually. So if it's okay, I'll sit. And thank you for that introduction. I didn't realize I was supposed to keep you awake, too, but I'll try. When I heard the title of this seminar, and maybe other speakers have mentioned it before, I couldn't help but thinking about an old Talking Head song called Stop Making Sense.
Oh, I remember that.
And this whole topic strikes me that way. It's there are lots of people who are making sense, yet the prevailing winds are stop making sense. And so I find it very interesting. I also like to say that I'll be speaking about just my own observations, and I'm not saying what my clients think necessarily. I need to get that out there right away in case any of them are listening. I don't want to get in trouble. And I also want you to know what I don't know. I really don't know a lot about fracking itself. What I do know about is the struggles of local governments to try to address their concerns about fracking. And I also want to say that I'll be talking about oil and gas generally and not just fracking, because even though in Howard Boygan's presentation he spent quite a lot of time differentiating between oil and gas development and fracking, and I understand fracking is the cracking of rocks underground, you can't do that without all the other stuff that happens, the traffic, the noise, the surface impacts that are related to it. So if I may, I'll just talk about oil and gas generally and not limit it to fracking. Is that okay? Also, what I'd like to do is, because I'm a lawyer, but I also think it's because it's important, I'd like to give you maybe 10 minutes worth of the legal landscape. I don't know how many presentations have gone into that to much of a degree.
There's no reason to think that everyone has been at every one of them.
Okay, so I'd like to just kind of set the legal framework first and then talk about some of the things that I've seen happening in Colorado and my own observations about them, and that's when you can make faces and hiss and things like that. And on the legal aspect of it, again, this is my interpretation of the law, and so for those of you in the room who are lawyers in this area, feel free to make faces at me during that part too. So first of all, on the legal landscape, I'd like to start with a quote, and this is from the Colorado Supreme Court in 1992. The state's interest in oil and gas activities is not so patently dominant over a county's interest in land use control, nor are the respective interests of both the state and the county so irreconcilably in conflict as to eliminate any prospect for a harmonious application of both regulatory regimes. That was in 1992. That's the Colorado Supreme Court. That's the law, yet we have been litigating whether or not local governments have any authority over oil and gas since that time. So I just wanted to throw that out there. It's a little bit wordy, but I think the gist of it is really clear, especially when you look at the terminology harmonious application of both regulatory regimes. And I'll talk about what that means in the law and in the case law, because it also is reflected or not in what's actually happening. First of all, this is really important. I always tell people who are concerned about fracking and have heard that local governments are preempted, which means that the state or the federal government has taken away their authority to act. They always say, how do we know whether or not the local regulations are preempted? The very first thing that anyone is concerned about preemption should say is preemption is never presumed. That's black letter law. Courts always assume that both the state, federal, and local laws should be read together. That's the first step. And it's a first step that people forget about all the time, especially when the rhetoric gets hot and you hear different interest groups parlaying and wondering why their particular interest isn't elevated over another interest. So just always start with that. Preemption is never presumed. Black letter law, United States Supreme Court. The second thing is that courts have repeatedly upheld local land use regulation of oil and gas operations, repeatedly. In every single case. There's not a single case since the Oborn case, which actually was, and I don't want to go into details, but there's not been a single case since the late 80s where the courts have found that local governments do not have authority over oil and gas operations. The extent of that authority and what that means is determined on a case-by-case basis, and I'll go into that a little bit. The authority for this comes from state land use statutes, the same statutes that allow people to zone and plan. You're all familiar with comprehensive plans, master plans, zoning regulations. It's that same authority, and for home rule cities, also from the Colorado Constitution in Article 20. So you have a grant of authority to local governments by state statute and constitution that allows them to regulate the use of land. That authority has been upheld by the United States Supreme Court since 1926. But for some reason, when we start talking about oil and gas, it's as if local authority doesn't exist at all, or as if it's in question. And one of the questions I always ask myself is, I wonder why we are able to regulate every other industrial land use, but for some reason there's a question as to whether or not local governments have any say over oil and gas. We'll talk about that a little bit. The courts, as I said from the quote at the beginning, have directed that local regulations and state regulations must be harmonized. So when you see these two grants of authority and legislative enactments, you look at what you can harmonize with each other. Then and only then, if there's a conflict between the two, and this is in oil and gas law, do you get into whether or not there's a preemption issue. There's just a couple of things in state law where the state legislature has actually said local governments can't regulate this. There's just actually 2 or 3 specific clauses in the Oil and Gas Conservation Act that limit local government authority. Other than that, you automatically go into what's called an operational conflicts analysis. And that's, again, only if you can't harmonize them. So the first step is so important. There are, as I mentioned, a couple of regulatory provisions that are expressly preempted. That means the state legislature has said local governments have no authority here. An example of that, of express preemption, is a local government cannot charge an oil and gas operator for the cost of their inspection of operations that are regulated by the Colorado Oil and Gas Conservation Commission. There's 2 other provisions, but they're very narrow like that. That's all that's expressly preempted. Then when you get into the operational conflicts test, the burden of proof, which means the person who has to prove up the case, has to show, and this is a quote, has to show that the effectuation of the local regulation materially impedes or destroys the state's interest. The state's interest being the interest in full recovery of the resource, getting the oil and gas out of the ground. So again, I'd like to repeat that in Colorado, except for these 2 or 3 express preempted areas, the local government authority stands unless it materially impedes or destroys the state interest, and whether or not that happens has to be proven by the person challenging the local government regulation, and it has to be done with an evidentiary hearing on an ad hoc basis. Again, you would think that that never was the standard, even though that was established in 1992 by the Colorado Supreme Court, because that's litigated over and over again. Another thing that you'll hear people say is, well, the local government really can't get into regulating the impacts of wildlife, for example, because now the Oil and Gas Conservation Commission has the authority to address impacts to wildlife. Wrong. These 2 grants of authority, the grant of a local government to look at wildlife and the Oil and Gas Commission, have to exist together unless the local wildlife regulation materially impedes or destroys the state's interest in regulating wildlife. There's an important case that said just because the local regulation and the state regulation address the same subject matter, they're not automatically preempted. Yet you will hear people talking about that all the time. Examples in the real world of what local authority has been upheld against facial challenges. That's where someone just comes into court and says, your regulation on wildlife, your regulation on setbacks, your regulation on water quality are preempted, just by the way they look. Again, the courts have over and over have said you have to go into an evidentiary hearing and prove that those two can't be harmonized and that there's this operational conflict. So some examples of things that have been upheld against that kind of facial attack are compatibility with adjacent land uses, impacts to recreational areas, soil and erosion control requirements, water supply protections, water quality of streams and water body setbacks, wildlife and wildlife habitat standards, air quality standards, noise, as long as they don't conflict with state noise standards that have been established, traffic, impact to roads, impacts to local government services, waste management, emergency response, and so on. So those are examples of things that still stand that have not been shot down as facially preempted by the state statutes. Yet, right now there's litigation happening in several arenas where those very questions are being raised all over again, and arguments are being made that those are facially preempted. You just can't do those things. I know this is a little tedious, but I think the backdrop of the law is important. The other part that's kind of tricky here is most attorneys would say that local governments probably can't regulate the downhole activity of fracking. So in other words, the size of the bit or the drill casing or the methods of actually drilling, that is covered by the Oil and Gas Conservation Commission. That's probably true because local government land use authority really doesn't get into regulating industrial operations. So I think that's probably true, but I wouldn't say absolutely true. And I think that people have an ever-expanding concept of what technical means who want to argue that you can't regulate anything technical. In a very recent case, they argued that a technical regulation was a surface-related impact of an oil and gas operation. So just look out for that. You'll hear people saying that. Pause and think about it. It's going back to that same case in 1992 where the court used that as an example of something that could be preempted, yet people in many, many lawsuits use that as per se. You can't talk about anything technical, and technical has grown to be huge. So that's the backdrop of the law. Local governments have quite a bit of authority, I believe. Every year we hear about people trying to propose legislation to increase local government control over oil and gas. Many of you in the room have worked on those things. I don't really think they're necessary, and I know there's a lot of people who say we'd like to clarify local government authority. I don't think it needs to be clarified either. I think it's really clear that if someone's challenging, they have the burden of proof to show that the local regulation materially impedes or destroys the state interest. So from my perspective, I don't think we need any more legislation. I think that a lot of this has come to a head, and there's actions and reactions that are going on that I think are interesting in the state. Of course, the first is the increase in density of well drilling along the Front Range and the recent concerns about fracking because of changes in technology. The first local government permit for an oil and gas operation that I was able to find was in 1955 in Pitkin County. Oil and gas has been going on for a long time in Colorado, and fracking's been going on for a long time in Colorado. I'm not saying whether or not fracking's okay or not okay, and there are certainly impacts associated with it that need to be mitigated. It's not a new thing. However, when this issue first started getting national attention, many of the Front Range local governments were caught off guard. They really were. And, before they had had a chance to think about it in any kind of measured, deliberate process of planning, they were hit by public, who was very, very concerned about the issue. Gaslands, the film, and many other issues that came out of Pennsylvania and New York, where the public was ahead. Well, not that it's that unusual. The public was ahead of the elected officials and demanding that people do something, but they were coming to local jurisdictions who had no experience at all. Meanwhile, on the West Slope, where local governments had been regulating oil and gas for many, many years, going back to the 50s, they were suddenly going, well, what's the big deal here? Of course we have regulatory authority. So I think that that's part of what's happened and why things have gotten to the place where they are. There is also quite a bit of very, very different points of view, which is good about local governments, in that for some people, they saw oil and gas development as a godsend in terms of economic development, whereas other local governments, especially those in the headwaters of the Colorado River Basin, or local governments who are in tourist areas where hunting and fishing and rafting are very important, see the environment as economic development. So there's a clash there happening. And also there's a whole divide of how local governments in Colorado look at oil and gas and fracking, from, I would say, Weld County and Greeley being the most welcoming to the activity and to their relationship with the industry, to, we love to pick on Boulder and Boulder County, Pickens County, the usual suspects on the other side. And that's because of the community that they represent, the interests they represent, and the way they've conducted their land use planning since the beginning of time. There's also conflicting attitudes about the existing regulatory regime. Some of the public believe that the environmental regulations imposed by the federal government and those imposed by local governments will be stricter than those imposed by the state government in Colorado. And that comes from a concern that the COGCC, the Oil and Gas Conservation Commission, is too closely aligned with the industry. There's many points of view on that. There have been legislative changes to its composition, but there's still the idea that the Oil and Gas Conservation Commission is in bed with the industry because so many of the people on the commission come from an industry background. Others are concerned about exemptions, because the federal exemptions for the temporary injection of the fracking fluids, and they're concerned that the federal government is in bed with the oil and gas industry and they much rather have it regulated locally. Then there are people who believe that the local jurisdictions are too easily persuaded and that they'll never stand up for what the public wants. So there's this, many, many, many different perspectives, and I would say they're all true and none of them are true at the same time, because none of this is as black and white as people try to make it appear. But there's definitely some distrust about the state and federal role in Colorado. And I think there's some reasons why the distrust arose that I'll talk about a little bit later. Also, I found that the environmental community, whatever that means, is not really aligned in terms of what they think about oil and gas development and fracking. For some of the environmental groups, they have a national goal of getting rid of using any fossil fuel. So from that perspective, you just stop it, and you do whatever you can do to stop it. And these nuances that I've been talking about are just bothersome when your goal is to get rid of using fossil fuel altogether. There's other environmental groups who look at natural gas development as a good thing because they see it as a bridge, getting off of oil, moving away from fossil fuels. So they're more willing to work on these issues, to propose legislation to strengthen state laws, and they don't really have the same national objective of getting rid of using fossil fuels altogether. Some of the environmental groups are also very much focused on local health considerations, while others are not. They're strictly focused on the environment. And some of them believe that they ought to be participating in the state rulemaking process, trying to make the rules as good as possible, while other environmental groups think that they ought to grind everything to a halt because none of it's worth trying to save. We should throw everything out. There's a debate in the environmental community as to whether the state regulation should be a floor or a ceiling. The idea that if the state regulations are a floor, they ought to say so and allow local jurisdictions to impose more stringent regulations. There are others who think that I guess, I don't know how else to say it, there are other environmental groups who want to spank some of the local governments because they feel that they're too friendly towards oil and gas and fracking. So there are people who would like to see legislation that would force a community like Greeley or Weld County to have much more stringent standards than they do right now. That runs afoul with lobbying organizations like the Colorado Municipal League and Colorado Counties Incorporated, who are more than happy to join in the fight for strengthening local control. And they're like mama bears when it comes to anything that would interfere with local control. Yet when you tell CCI or CML that you're going to spank Greeley or Weld County and and force them to have more stringent standards, then you lose them as an ally, because local control is local control, for better or for worse. So that's another complicating factor in all of this, and one of the reasons why there hasn't really been any good legislation that's come out that's, quote, solved the local control problem. Then, of course, you have, confusing everything, you have the national movement to ban fracking, which some people refer to as outside agitators, which sounds like the 60s revisited, where they've based their points of view on the experiences in New York and Pennsylvania. New York and Pennsylvania have different kind of shale, different kinds of issues, different kinds of home rule authority and local government authority and oil and gas regulations, but that's been a huge impetus towards things getting the focus that they've had here in Colorado. Another confusing item was the governor's task force on oil and gas and local government. We met for I don't know how many weeks, and the upshot of it was, well, gosh, we really ought to just get along, and nothing really came out of that. There was no leadership that came from that. No one said, how do we just get along, and it was sort of left dangling. The amendments to the COGCC rules that just happened left a lot of issues unresolved. And ironically, every time the Oil and Gas Conservation Commission gets stronger, better rules, that's another argument for the state and industry to say, local governments, get out of the way. We're taking care of it. There's been very aggressive legal responses to local concerns. I think that one of the things that happened, and again, please accept this as my personal opinion, one of the things that triggered a lot of the taking of sides and the black and white thinking was a memorandum that was sent to local governments to whom the idea of regulating oil and gas was brand new, and that was a memorandum prepared by the attorney that represents the Colorado Oil and Gas Conservation Commission. In that memorandum, it took a very conservative perspective on local government authority, and it ended up having a chilling effect on local governments who were thinking of adopting oil and gas regulations. So that was an aggressive legal response. And then lawsuits in which the state has actually sued local governments. That's not new. Back in the early 2000s, when Gunnison County was defending its oil and gas regulations against an attack by the industry, the state of Colorado intervened in that too. But the publicity has happened around what's going on in Longmont right now. And it raises really interesting public policy concerns to me when the state is suing its local governments over their authority in oil and gas. And so I think the final result of these dynamics has been 2 bans and 2 moratoriums that you all know about, and hundreds of bans and moratoria around the country. Reportedly, the Oil and Gas Association, which is the state trade group, spent about $900,000 opposing the 4 ballot initiatives. That's a lot of money to be spent. And the anti-fracking groups raised about $26,000, yet the initiatives passed, or referenda passed. And then we know that Longmont's been sued by the Oil and Gas Conservation Commission. Fort Collins has been sued by the Oil and Gas Association. Lafayette's been sued by the Oil and Gas Association. And Broomfield's been sued by Broomfield's Balanced Energy Coalition, which is a group of people that are in favor of fracking. from my view of public policy and a situation that's healthy, I would say these are all examples of something that isn't working very well at all. I guess it depends. I did disclose that I do represent local governments and I do get paid to represent them, yet I find it would be much better if this money were being spent in developing some kind of complementary or harmonious approach to oil and gas regulation. The other thing that I've thought a lot about that Patty and I talked about before is why is oil and gas so different from, say, mining or water development? In Colorado, water is an extractive resource, and minerals that you mine are an extractive resource. And you would think that the issues would be very similar. I've thought about that a lot, and I'm not sure about what the difference is. They've followed similar paths, like back in the 80s and 90s, the very first lawsuits on whether or not local governments had authority over water diversion projects were the people challenging local regulations took the same absolutist position: get out of here, you have no authority, we get to develop water, the Constitution says so. So they started with the same perspective. And the old cases on local control over mining. There was a case in the early 80s that came out of Crested Butte, who is still trying to fight the Mount Emmons mine, or whatever it's called now. And in that case, again, the industry took the position, you have no authority whatsoever, you get out of the way, we're in charge. But over the years, as there were a series of local government victories, both industries have shown much more willingness to work with the local governments. And I also need to say that there's some wonderful, wonderful industries in oil and gas. There's some wonderful companies who have worked really hard with local governments. Gunnison County is a great example. There was a good guy and a bad guy. The good guy worked with the county when it was trying to pass its regulations. The bad guy sued the county before the regulations were even finished. So I'm not really sure about. I can't draw the industry with a broad brush here, and I want to make very clear that there's different kinds of approaches. Yet, by and large, what you hear about and read about, what seems to be driving state policy, are the representatives of industry who say, "Get out of the way, the state has it covered," and they're the ones who are using this argument of preemption over and over again. I also thought that maybe there's a reason why mining is different. No one questions that there would be zoning or land use control over a gravel pit, yet it's highly regulated by the state. No one questions that. I mean, you would be appalled if you were to go to a county commissioner meeting and hear the county commissioner say, "We don't have any authority over gravel." "Yeah, they can do it over here in this park." I mean, that would never happen. Why is it that we look at oil and gas so differently from mining? They're both minerals. They're both protected. They both are encouraged to be developed by state statute. Why are they so different? Well, maybe one of the reasons is that oil and gas isn't in here for the long haul the way mining is. When you think about it, when a mine sets up, even a gravel operation, it's usually there for a pretty long time, and they become part of the fabric of the community. And they typically hire local people, whereas oil and gas operations, with exception, tend to be much quicker. The drilling operation is fast. All of a sudden, the drill's there. They're in and out. The workforce is often transient. It comes from other places rather than locally, so maybe that's a reason. The industry also, many of the companies that are more litigious than others are used to working in states where oil and gas has never been questioned. People love to turn around and see an oil and gas well in certain states in somebody's backyard, and that's part of the mystique and mystery and beauty of the state. They've been very surprised that Colorado doesn't see it as a wonderful economic development opportunity, although our governor certainly supports it as a huge economic development tool. They've been very surprised, caught off guard, that people think that maybe that conflicts with tourism and recreation, which are the rising industries in Colorado. I also think that there's this, the oil and gas industry, again, painting it with a broad brush, tends to see the Colorado Oil and Gas Conservation Commission as taking care of all the problems. You know, they honestly believe, not just as a strategic position, but they honestly believe, what else is there? These oil and gas rules are very comprehensive. Why do we need local government? In fact, in one case that our firm worked on in Gunnison County, the people that were representing the company that was challenging Gunnison County's regulations came into court with boxes filled with statutes saying, look, Your Honor, we're already subject to all of these. We don't need local regulation, as if somehow the weight of it all would influence the judge. They lost. The Commission's suggested state-level only approach, again, I think, you know, the people on the Colorado Oil and Gas Conservation Commission are incredibly hardworking, well-meaning people. You know, maybe they get paid $1 a meeting. I don't know. I mean, this isn't a case of graft and corruption or anything like that. But what they don't really understand is local government, and they don't understand that the local government land use process is really the only effective forum where local citizens can have a say and listen to the impacts of the operation. Because the commission, the Conservation Commission, has no public hearing process. And the only people that can even challenge the issuance of a permit to drill are the landowner, the operator, or the local government designee, which doesn't really cut it. It's not the same as being able to go into your county commissioner's room or your city council chamber and hear the industry put on its case as to why they're going to satisfy the local standards. And I think that's a huge part of the problem here. And there's also this idea that if that were to happen, if people were able to go to the local government, that the NIMBYs would control, not in my backyard. Yet that really isn't so. I think that kind of discounts the very careful processes that most local governments go through. They know that if someone is able to prove that they're satisfying the local government land use standards, that they have to approve it. It doesn't matter if the room is filled with people who are objecting to it. They know legally that if they've satisfied the standards, it has to be approved. So there's no place. And there's no place for the industry either. The industry is out here in the stratosphere saying, trust the Oil and Gas Commission, trust us, fracking isn't bad, we're going to take care of the impacts. Yet there isn't that ability to cross-examine the representative from the industry or to really question their research or their statistics in a public process that you find at the local level. So I think it's almost like shooting yourself in the foot by objecting to a local process when, in fact, if I were an operator, I would welcome the opportunity to show how I was going to mitigate my impacts and fit into your community. There's also been really no comprehensive overture from the Oil and Gas Conservation Commission or the state to local governments. There really hasn't been any efforts to talk in a setting that isn't too charged. Unlike mining, where the Mineland Reclamation Board actually went out on the road and had meeting after meeting after meeting about 10 years ago with local governments to try to explain what the mining regulations could cover, what was left unaddressed, and where they needed local governments in partnership. I think there have been some overtures by local governments to the state that have been rebuffed. I think that if you look at water as the example, there have been historic agreements between the East Slope and the West Slope on water diversion projects after years of litigating. But that may be because the water diversion projects are the proponents of those projects are other local governments, so they have more of a public policy orientation and they understand that they have to work together in a complementary fashion. Local governments haven't stepped forward in any kind of united front. In the water example again, many local governments got together who were trying to protect their streams from trans-mountain diversions, formed a coalition, and then approached the Front Range and said, we'd like to work with you. We'd like to figure out how you can get water for your people on the Front Range and how we can protect our streams and our rafting and our recreational amenities. So I haven't haven't seen this happen. I haven't seen an organized approach by local governments to the industry or to the state about some kind of complementary regulation. And then I think the insistence of many in the industry on uniformity of regulations really misses the mark, because I mean, every industry wants uniform regulations. Wouldn't it be easy if every single local government land use code looked identical and you could just check the boxes? But the reality is the hydrogeology and the culture is so different. What does Yuma County have in common with Pitkin County in terms of the geology, the culture, the resources that are of concern? There's no comparison. And that's why local land use authority has been seen as something that is carried out at the local level in Colorado since it began. Even in the early 70s, there were attempts to do statewide planning, and they were rebuffed, and the courts over and over said, hey, local land use authority belongs at the local level. So I guess to finish up here and allow you all to ask questions, I think that with something as controversial as this, with so much conflicting information as to whether or not it's good, whether or not it's bad, with reports of accidents and spills and leaks along the way, we need all eyes on the ground. And I think the intelligent perspective would be to make sure that we in fact have some overlapping responsibilities, because it takes everybody. It takes a village to raise an oil and gas well. We need everybody looking at what the impacts are, and who better than the people where the impacts are actually occurring to keep an eye on it. And I think that where things really probably went wrong and we lost the ability to move in that direction was when oil and gas became embedded in people's minds with national security. And once you're talking national security, that changes everything. That changes whether or not people eavesdrop on you. It changes what's disclosed, what's not disclosed. And I think combining the two in one sentence really set things on a course that's difficult to move back from. My recommendation would be that we dust off what used to be called the Colorado Joint Review Process, which was a process that was designed back in the oil shale days when oil shale was booming in the late 70s and early 80s, where the state convened early meetings before anyone made any plans, before any environmental impact statements were written, and they brought everybody in the room, the affected interests at the different levels of government. They talked about everybody's regulatory authority and resources, who could manage this, who could manage that, and they put together a plan forward that was followed until the end. So that's all I have on my observations, and thanks for your patience, and I can't wait to hear your questions.
Okay, I do have questions here, and I have them in some categories. I think I might begin with the ones on which you have claimed no expertise, okay, so that you can then reclaim that you have no expertise, and okay, will have, or maybe you will have hidden knowledge that you would like to unload here. So, does fracking cause earthquakes? Is there an increased danger of minor earthquakes as a result of fracking?
I think that the evidence is inconclusive on that point. I've read articles that say it does, and I've read articles that say it doesn't.
The distinction between the injection of water versus the fracking as a possible cause, is that?
I think the claims that I've read where it has caused earthquakes is the injection of fluids into the rock.
Okay, are you going to be getting a master's degree in geology that would allow you to answer that question? Have we discussed dry gas, wet gas, and associated gas? And the answer might just be no, but unless there's something you'd like to.
No, my focus was much more on local responses to those issues.
Okay, then some water questions, water use questions. Comment on waterless fracking.
Yeah, I don't know. I see Matt over here. Do you have any comments on waterless fracking?
No, not that I would like to share with the crowd. We can talk about it though afterwards.
Yeah, I just don't know. I think that we should explore all options for fracking, from, quote, green fracking to waterless fracking to all the different technologies that are available rather than fighting over whether local governments have any authority.
Do you believe water use and fracking presents or will present serious concerns for other water users such as cities and farmers?
Yes.
That is, does or will fracking use too much water?
I don't know too much. It's a huge, sorry I don't have the figures at my fingertips or my brain tips, but it uses a huge amount of water, and it is an issue, and a lot of people right now are trucking it into the location, and they're getting it from municipal providers. On the West Slope, it's an even bigger issue where water is more scarce. I think that the Colorado Water Plan is looking at that issue. The Colorado Water Plan, for those of you who don't know about it, is something that's been initiated by the Colorado Water Conservation Board, where they're looking about a future gap between water supply and water demand, and in that analysis they're looking at the demand from fracking.
Okay, one or two more water ones. Given that water sold for fracking is totally consumptive, are there any challenges to sales by municipalities?
There haven't been any challenges yet. That did come up, interestingly, when Grand County was reviewing the local land use permit for the Windy Gap firming.
Fracking wells and increased risks of various concerns for surrounding residents. This is maybe about the recent public health studies, but I wonder if I could direct that question to how local governments are to be positioned to take in the really difficult to interpret contested information from public health.
Right, and that is, you asked two questions there. Part of the Oil and Gas Conservation Commission's perspective is local governments don't have the expertise that they need to evaluate those concerns, whereas the COGCC does. However, in any local government land use process, it's just like if you were a judge and jury. When you go to court and on jury duty, you don't know anything about the issue in front of you. You're taught to listen to the evidence, to weigh it, to evaluate it, and to draw a conclusion. So it's the same for local governments. You don't have to be an expert in the industry. You have to be able to weigh in, the evidence and credibility and decide whether or not the applicant has met its burden. What was the other part?
Yeah, just that whole question about, well, I guess this was particularly...
There was another part.
It was about the recent study, I guess.
Right. So, Fort Collins, for example, the moratorium, the referendum in Fort Collins is for the purpose of studying the human health impacts and the property value effects of fracking. And the city will be going through a process of understanding exactly what's out there. And I think all local governments are very concerned about the conflicting reports and studies. There just isn't anything that they can hang their hat on. So I think that local governments will need to bring it back to the local level and say, in our community, what does it mean here? And they'll have to hire their own experts to refine the national studies to the local level in their community to see what it means.
A particular question about the Gunnison case. What was the outcome of the state's intervention in the dispute in Gunnison over drilling regulations?
Gunnison won. The state and the industry said that the Gunnison County regulations were facially preempted, and the court disagreed with that and upheld all of the county regulations against the facial challenge and said to the state and industry, you're going to need to come back and have an evidentiary hearing if you want to prove to the court that these regulations are preempted, and neither the state nor the industry chose to do so. So the Gunnison regulations stand.
What exactly is the Halliburton loophole, and how has it affected the regulatory requirements in Colorado, and has the loophole been adequately addressed or changed by Colorado's regulations?
The Halliburton loophole, the way I understand it, is an exemption for certain fracking fluids in the initial injection to begin the fracking process from the underground injection well requirements that are under the Safe Drinking Water Act. That exemption still holds, And however, when produced water comes back up again and the fracking fluid has finished its process, and you want to put that back down in the hole, that is covered by federal regulation.
Okay, here, I think I have a little handwriting issue here, so we'll just work together on this. I recently heard Louisiana oil and gas people, landmen, say that British Petroleum controls the United States. The reason would seem to be simply power over so many aspects of our lives and government. Do you agree?
No.
Okay.
Because local governments do have control.
Right, and we do cover all questions, and now I really am moving into the center stage kinds of questions here. COGCC, please differentiate between COGCC Commission and COGC staff.
Okay.
What do each do?
Okay, the Colorado Oil and Gas Conservation Commission is the body that's in charge of adopting the regulations, drafting the regulations that are then applied by the staff on a day-to-day basis. It's the staff that has the inspectors. It's the staff who implements the regulations that the commission approves.
And the staff are
So the executive director of the Colorado Oil and Gas Conservation Commission actually is in charge of the staff. And he's not...
The staff?
Pardon?
Who pays the staff?
We do. We do.
State.
Right. They're state employees.
our neighborhood especially, Jerry. This is my
Yeah.
neighbors. We really
You
do our
do.
part, yeah. How can people comment on pending drilling permits?
The best way to get engaged in the structure that now exists is to first of all figure out in your county or municipal government whether or not they've designated a, quote, local government designee, an LGD. Do they have such a being? The second thing is to make sure that your local government understands that they can regulate oil and gas and that they've really given some serious thought to the extent of that authority and not been dissuaded from doing so by people who take these absolutist positions. And then third is to make sure that if they have this local government designee, that the local government designee is paid enough to pay attention to pending applications for a permit to drill. They have 30 days to comment on those. So you want to make sure that somehow the local government has set up a process where they have a way of notifying the general public, and then the general public can input through the local government designee. It's tough with that really short time frame, but those would be my 3 suggestions.
And really, please comment on the LGD program was the next one, so that.
Yeah, it's the state often uses that as an example as to why we really don't need local government authority, because there is a process where the LGD can comment on an application for a permit to drill and can even ask for more time and can challenge the application for a permit to drill. As far as I know, and I might be wrong because my information is about a year old, as far as I know, Gunnison County is the only county or municipal government that actually went through that process and challenged an application for a permit to drill. Does anybody else know if anyone else has done that? So it's almost like a latent process that needs to be revived.
Okay. 2 questions about MOUs. Memos of understanding. Do you think the MOUs being entered into by municipalities and operators have any teeth in increasing environmental and health protections over the COGC regulations? Is there a model MOU in that respect in Colorado and closely allied? How effective can operator agreements with local jurisdictions be? Is this tool underutilized? Well,
that is a good question. My personal opinion on that, just not my client's opinion, my opinion is that, first of all, to have an MOU process, you have to have some regulations in place. And most communities that use it do it as an either-or. Either you come through our land use regulations that apply to oil and gas, or you enter into an MOU with us. And if you enter into an MOU with us, we're going to impose more stringent standards on you than we think we could under our oil and gas regulations. So I really believe that you have to have the regulations in place. I don't see them as a substitute for some kind of regulatory structure. Then legally, there are There's an open question legally. There's arguments on both sides as to whether or not they're enforceable in the long run. Those who don't want to see memorandums of understanding enforceable will say that one elected body can't bind a future elected body. I think you've all heard that. Whereas other people say, no, local governments enter into contracts and agreements all the time. They are enforceable. To me, they're just like a development agreement, which local governments have used for years in other land use contexts, or like a PUD, a planned unit development, where you say, don't go through these regulations, come through this process and we'll negotiate an outcome that's better for everybody. So I think they're good tools, but I don't see them as instead of local regulations.
Could you speak about concern about noise and viewscapes? And this person says, calls to your attention, a recent trip to Pawnee National Grasslands was severely degraded with loud noise, truck and wells, and the magnificent views and quiet were interrupted and degraded. So local government and noise and viewscapes.
I draw your attention to the Department of Local Affairs. The Colorado Department of Local Affairs has a handbook on local regulation of oil and gas. And in there they have a whole list of techniques that local governments could impose without running into preemption on oil and gas operations. Noise, the local government can't set its own noise standards, but it could put in place things like barriers and buffers and things like that as a requirement to mitigate the noise. Visual impacts, there was one case in the Colorado Court of Appeals where the court said, actually it was the town of Frederick, where the court said, sorry, you can't regulate the visual impacts of oil and gas, yet in other cases on a facial challenge, visual impact regulations have been upheld. I would say go for it, because just like any other industry, why not? As long as you don't interfere with what they're trying to get out of the ground, you could impose visual impact requirements.
Knowing the precedent of the 1992 Supreme Court ruling, why is the state sponsoring lawsuits against local government who dare to restrain oil and gas?
Well, I hoped I talked about that a little bit. I think there's so many factors involved with that, but I do believe that the state honestly believes that the Oil and Gas Conservation Commission has it covered, and that what you'll hear often is the industry and the state, when I say that, I mean probably the governor's office and the Oil and Gas Conservation Commission, they say it would be terrible to have a, quote, patchwork, close quote, of regulations that apply, and that it would really impede the industry from being able to get this valuable resource out of the ground. But I hope I covered many other reasons why I think that's happening.
Would you care to speculate on the likely outcome of lawsuits against Longmont and Fort Collins?
Well, I would have to say that I have absolutely no idea. I have my personal opinion, but being involved in one of them, I really can't say.
Okay. Hasn't the state interest changed since Bowen versus Edwards? Does the state interest as written in oil and gas statutes now include protection of public health, safety, welfare, environment, including wildlife?
Yes, it does, and that was actually used as a sword by the industry and the state. Once those additional authorities were added to the state, they said, aha, now we've preempted you. It used to be that local governments could worry about those sorts of considerations, but now the state does it, so get out of the way. And the courts disagreed with that. In particular, when the act was amended, there was a savings provision that saved local government authority over oil and gas operations.
Okay, going back a little bit over to the more wide-ranging side over here. Is there any discussion about leaving some oil and gas in the ground as a prudent reserve for long-term energy planning policy?
I have no idea. That would be something to ask one of the industry people.
If the fracking boom took off in the late 1990s, would there have been a need for the Iraq War?
If a bullfrog had wings.
It's an interesting.
It is. It is.
Counterfactuals. Historians are not so good with counterfactual questions.
That's great.
That's an interesting one. What jobs are there for women? I'm going to take this question, which I think may not be quite in your So I'm going to expand it a little bit to an area of interest. What jobs are there for women, for a woman with a MS, with a master's degree in hydrogeology and in fracking?
Wow, lots of jobs, whether you're a woman or a man. It's such a growing industry. Whether you would go to work for a local government planning department that's well-heeled enough to hire you, or whether you would go to work for the industry, that it's a huge. The industry has many examples of women, technical women, in pretty important positions, as do local governments. One aside there, local governments do have the authority to hire outside experts to review an oil and gas application and charge the cost of those outside experts to the oil and gas operator who's applying for a permit. That's really important.
You discussed the industry claims of state preemption. How about the claims based on split estate?
Those are claims between the surface estate owner and the mineral estate owner. Local governments don't get involved in that level of dispute.
Since essentially all natural gas comes from wells that were fracked, isn't it hypocritical of voters to vote to ban fracking and then to use it to heat their homes? Well, not use fracking to heat their homes, that's going to be kind of a mess if they try that. But students of mine, watch those antecedents to pronouns, because that can become very confusing. So let's start this again. I'm sorry. Since essentially all natural gas comes from wells that were fracked, isn't it hypocritical of voters to ban fracking to produce natural gas and then use natural gas to heat their homes and cook their food?
If that standard of hypocrisy were used to measure any kind of progressive movement towards a change from the status quo, nothing would ever change, because there would always be a measure of hypocrisy, if you want to look at it that way, unless you've given up everything and live naked in the woods. It's a tough standard.
Might there be gradations in hypocrisy?
Of course, and that's exactly the point. There's gradations of hypocrisy, and we have to all look at that ourselves. I mean, I'm sure if I were to ask people in the room, are you an environmentalist, many people would raise their hand. Yet, if I said how many of you drove here, there would be a lot of hands too. Mm-hmm. It shouldn't keep people from thinking about these issues and trying to see things change towards a better world.
This is a wonderful question. I want to really accent the word can here. What can be done to create a harmonious body of agreements or a harmonious situation in this area, given that use of the word
the harmonious application. I honestly believe there are examples in other arenas of that being done successfully. There's a need for leadership. Somebody, whether it's a coalition of local governments or a coalition of oil and gas companies or the governor, needs to step forward and convene a space in which the dialogue can occur outside the courtroom. And there have been wonderful symposium like this and others that are happening where people are becoming educated. But I haven't seen real leadership, any one of those interest groups stepping forward and saying, hey, let's really get a grip on this and stop spending all this money on litigation.
And I have a couple of follow-up questions on that. Which you really have kind of preempted, if I might use the word preempted, of why can't you initiate that conversation? Why don't you do that?
Barbara Green, me?
Oh.
You guys want to talk? I think because I actually have clients who have to take legal positions in litigation, that's difficult right now. But certainly through that opportunity that we have, Gunnison County made some wonderful overtures to the state. They took a real leadership position once their litigation was ended and approached the state and talked about helping draft some model regulations that could be used by other counties and municipal governments, and said that they would gladly convene some discussions. But this was the previous 2 Oil and Gas Conservation Commission directors ago was just not interested. But I think it takes a lot of time and fortitude to get those going, and you need a receptive audience, and maybe the time's right again to initiate something.
And maybe just following up for a moment more on that. You said, I was very struck when you said that you didn't see overtures being made by the state to the local governments, nor did you see the local governments really coming into that. So where's the galvanizing or the
Yeah, I mean,
catalyzing of that?
well, right now, I would characterize the local governments, especially on the Front Range, to whom this is all new, in a duck and cover mode. I mean, you're forced into a defensive posture when the issue is brought to you by the public, and you're just trying to get your head around it, and then you get a memorandum being told that you really have no authority, and lawsuits are filed by the state against you. So I think until this litigation runs its course, or perhaps during the course of the litigation, that it's a normal reaction to just duck and cover and do whatever you can to defend yourself. When you go to the Colorado Municipal League annual conference or the Colorado Counties Incorporated, they're talking about it all the time. But local government right now is divided among itself too. Because they see things as black or white. You're either for oil and gas or you're against it. And we need to get a more nuanced view going before we can have any discussions.
And then I'd like you to reflect a little bit on where we intersected on what you have spoken about of the water utility business, water utility operations changing their approach to local communities. And I know this is a tough thing because thinking sentimentally and warmly about Denver water is not in everyone's emotional vocabulary.
Yeah, well, Denver water did change enormously. When I first started working on water issues and this whole debate about Trans Mountain diversions was peaking, and the chairman at the time, not of the board but of the staff, I think he's called the president or executive director of the water board, basically came to a meeting of a coalition of local governments on the West Slope and the headwaters of the Colorado River, and they said, you know, we would like to talk to you about the impacts that you're going to cause if you keep taking more water up here. And his response was, then you've got to stop trying to regulate me. Whereas through the leadership of Jim Lochhead and his predecessor Chip Sperry, who both have a much more public policy perspective and a statewide approach, the rhetoric was dropped, except at some kind of backroom levels of the organization itself, and there was this willingness to the place where Denver Water is saying that they are proud to be sponsoring a Trans Mountain diversion project that will end up with the river system being better off after the project than before. So it's a huge shift in thinking, and I think it was individuals, I really do. Plus being beaten in court.
Right.
They
Two Forks didn't
Two Forks, and then the cases where local government authority was upheld over and over again for Trans Mountain diversions. The combination of all of that really changed the rhetoric to the place where conversation was possible. But also in the water case, a coalition of local governments approached the East Slope, and they put together a 3-day forum where they talked to Aurora and Colorado Springs and Denver and places that they'd been litigating with for 100 years. So they actually convened, and it was called something like Across the Mountains, and convened a 3-day discussion.
Is the structural difference, though, that there is a big concentrated unit called Denver Water that can move around, and there's no such counterpart thing on the oil and gas industry? There would be no...
Well, that's part of it. Also, however, the Colorado Oil and Gas Association seems able to be very consistent in its litigation strategy on behalf of the diverse industry. I think the Denver Water is a perfect example of someone with the power and control to be able to speak with one voice. But COGA is a pretty strong outfit, and I think maybe they could pull something together too.
I was skeptical and did not snort skeptically, or sigh with exasperation, but when you said that you thought people on one side might fear the nimbiness of local government, but you thought that fear was ill-based, and...
Okay, yes.
So,
okay, let me explain that a little more. A well-run local government applies its regulations in an even-handed way according to the law, and if an applicant presents a case and shows that its impacts will be mitigated, the permit is issued. Evidence on that is last year there were about 4,400 permits issued in Colorado. Of those 4,400, only 200 and some did not have some kind of local review process associated with it. So if local government NIMBYism were controlling, that statistic would be impossible.
Just a couple of questions. Is a ban or a moratorium a regulation, or is it a don't let it happen so that we don't have to regulate it? Or what is, I've been struggling, I guess I should have thought of this a long time ago and figured it out, but what is a ban or a moratorium? Is that in the category of regulation, or is that in the category of get the hell out, or is that a regulation? I guess it is.
Yeah, that's an interesting legal question. A ban is different from a moratorium. A ban is you're done, you're out of here, you can't come here. A moratorium has to be for some kind of limited period of time that equates to the time period to study or to evaluate or to plan. So there's a distinction between a moratorium and a ban, for starters. And then, is it a regulation or not? I think, in my mind, a moratorium is in anticipation of a regulation rather than a regulation in and of itself. A ban, because you can't do it at all, is, you're just done.
And then just one informational question. If, I guess, as a not attorney, I thought if there was a precedent and a significant Supreme Court ruling that was supposed to guide decisions or maybe even foreclose the need to be in court. So why, if there are these precedents and they are as unambiguous as you see them, why are people still trotting into courtrooms? Should somebody tell them that there's somebody parking attendant near the court?
Well, that is one of the reasons behind different people's approach to the need for more legislation on local control. There are people who believe that it needs to be spelled out, and if it were in state statute, everybody would understand what it is. What makes it tricky is, well, first of all, I don't know why people keep raising the facial preemption challenge over and over again. I don't know. And of course, courts can always change their mind if circumstances are different. So you use the arguments that you have available. And when you do a preemption analysis, you always you say right off the bat, you don't have any authority. And then you say, well, maybe you do, but not much. And then you get into this operational conflicts analysis. I think it's because the operational conflicts analysis is a case-by-case determination that, with every case, if I were representing an operator, I would say, well, in this case, clearly you're materially impeding or destroying the state's interest, and I'd want the court to rule on that. The facial stuff is a little harder to understand, but there's good arguments being made. And it's taking language and parsing a sentence that's this big into little bitty pieces to see whether, okay, maybe this time if I say it differently, I'll persuade the courts to look at it differently.
Well, and that brings me to my last two questions. And the first one is, since that sounds like something you would do in a literature class, really, of taking a line and parsing it down. So that opens the door to my question. If you could look at your career and your experiences now and you could think, if I had not been a lawyer, I could have worked more effectively at dealing with these issues if only I had thought to be a blank. What would that profession?
A florist.
A florist. That doesn't seem to be what I saw coming here. But are you going to take flowers around to the contesting parties and soothe them by that, or what?
Yeah, I feel very, very, very blessed by the opportunity I've had through my legal profession to be involved in these kind of public policy issues and to help local government officials do a good job at what they're supposed to do and to provide them with the tools to do it. So I'm pretty happy.
Okay. Well, then the last question has to do with social encounters on this subject. 3 days before Christmas, we were at a neighbor's party, and for 3.5 hours, because people know I'm working on this project, I could not get on the subject of Christmas or I had to keep talking about fracking, and that was challenging to me, but it's an opportunity. I also recognize it as an opportunity, and I think, for instance, about times at Western History Association conferences, a couple of times I've been in the elevator, someone says to me, what are you doing? I say, I'm working on a project on fracking, and the academic, who's supposed to be a little bit more expansive than mine, says to me, to oppose it, I assume. Yeah. And I think, I don't know that that's a very well-informed remark, and I hope the elevator doors will open soon before our conversation goes. So what are some discussion leading techniques for social occasions, dinner parties, or to have a more productive...
Invite different people.
Well, sure, but I mean, that's a good thing. So, right, who are we going to invite? What kinds of people, and how do we get the conversation moving in a direction that's not sterile and time-wasting?
When people ask me that question, and I don't know whether my response is scintillating or not at the dinner table, but my reaction is always like, I think that's missing the issue. The issue is how local governments and the state and the federal government are responding to the concerns that are being raised. And that's what's interesting, and that's where we should be focusing our attention. Because when there's this many people across the world raising a concern, how we respond to that concern is as important as what we say.
Wow, I'm glad I asked that question. So thank you so much.
That's a great answer.